Again, my name is Ryan Malkin. I have a law practice and I focus on the beverage industry. One quick disclaimer, this is all for educational and informational purposes only and not for specific legal advice. I'm going to go relatively quickly because I have a lot of information. So I'm going to tell you everything you could possibly want to know about starting an NA brand, but all within 10 minutes. So keep up, I guess, I would say, and then ask questions at the end. As you can see, some of the things we're going to talk about are which federal agencies regulate your product, and is it subject to excise tax, what has to appear on the label, and where can it be sold, and what type of retailer can sell your product. So this is just information you can find relatively easily online, so I'm going to kind of go through it pretty quickly. But the whole key with regards to non-alcoholic beverages is 0.5% ABV and below. That's kind of the threshold, largely, for whether or not the TTB is going to regulate the product, other than for malt beverages, where malt beverages are subject to TTB. Regardless, it's more about production versus and what it's made from versus the alcohol content. Wine, again, this is relatively easy to find online, and the slides will be available through Park Street University, I'm sure, later. And then here I was talking about for malt and cereal beverages. This is the one category. I know we're talking largely about NA spirits today, but a lot of, obviously, non-alcoholic beer is also quite popular and obviously the largest category within NA, so just wanted to flag this as well. All right, so on labeling, regardless of the type of product, meaning a NA beer, wine, or spirit product, you need to have the product identity. So you're going to talk about what the product actually is, any alcohol content, or whether or not it has 0.5 or below, and the net contents, manufacturer information. Whether or not you have to have a health statement or allergens is all applicable. If it's an NA product, then you don't need to have the government health warning, but these other warnings would be required. Here you can see, so from a regulatory perspective, basically you want to understand, is it TTB or FDA that regulates your product? FDA regulates, regardless of whether it's alcohol or not, what's in the product. So even alcohol products have to have ingredients that are generally regarded as safe, and TTB looks to FDA for that. But if you have a product that, let's say it's a non-alcoholic spirit alternative, that product would be regulated by FDA. And the difference largely between FDA and TTB from a market compliance and market access perspective is that TTB, you have to submit formulas and labels for pre-approval. FDA, there's no pre-approval process. So in some ways, alcohol is easier because you know from the get-go whether or not it's approved by the government, so it gives you some level of comfort. Even if the TTB approves something in error, then at least you can rely on them and say, well, you approved it in error, it wasn't my fault, and usually get a use up to keep using that label up. Whereas FDA, you kind of have to make sure that you review it ahead of time and make sure that you're using a good lawyer or somebody to review the labels to make sure you're not putting something into the market that's not compliant. From that perspective, sometimes it's easier to have an alcoholic beverage product versus a non-alcoholic beverage product. So I know that these guys are going to get into the formulation, the labeling a little bit more. So I'm going to turn and talk a little bit more about some of the other aspects of it. So once you actually have the product, let's say you're governed by FDA and you don't have to worry about getting different licenses and permits to sell into the different states like you might with alcohol. The issue, which they were talking about on the other panel, is that you're oftentimes still going through either an alcoholic beverage distributor, because maybe you have an NA spirit alternative product, and maybe you want to be in cocktail bars or in Total Wine or places that are traditionally more for distilled spirits distributor. The contracts that you're going to have are going to be the same as contracts that you're going to have with a spirit product or a wine product. And even if you went with a distributor that focuses on NA or food products, the issue is still going to be that the contracts are going to be the same. So while there might not be franchise laws like there would be for a beer or wine or spirit product, they're still going to lock you in the same way that you would be otherwise, right? So the Southern contract, RDC contract, breakthrough contract, what have you, are going to still have these perpetual contracts that failure to auto renew, they're going to be a penalty. Sometimes it's 5 times gross profits to get out. So you have to think about what's the term of the contract. You have to think about if you don't renew, what's the penalty, which could range again between 2 and 5x. And when do you get paid, right? So let's say one of the big distributors, they want to pay you on 90 days, or maybe they don't say it at all. Maybe you need to have to negotiate down to 30 days. All of these things are negotiable and interesting and not interesting, but really important for you guys to talk about and try to negotiate. The other thing you need to be mindful of is what are the duties of the distributor and what are the things that you want them to do. So obviously to maintain sufficient levels of inventory, maybe that's to have at least 30 days in stock, obviously provide you with certain data. These are other things. The biggest one, if somebody was going to say to me, review this contract, but have a light touch, and what's the most important thing? It's always going to be some sort of goals or KPIs to be able to get out, because most of the time, that's the only thing that the distributor is unlikely to do. Some of these other things, they may not necessarily, right, maintain sufficient inventory. There's always going to be a cure period. So you're like, hey, you don't have enough inventory, but then they cure it by buying more inventory. Goals is the one where if it's an annual goal, then it's like if you don't hit it, you don't hit it. Oftentimes they'll have a 2-year requirement, but this is the one where if you had to pick one thing, try to get goals, make that material so that if they don't hit it, you can terminate the contract without paying. These are some of the other areas that you want to make sure that you hit, but these are not as important as goals. So if you had one thing to choose, that would be my choice. So just think about how you're going to get out before you get in. Think of a distributor contract largely as a prenup, and make sure you know how you're going to do it. All right, and then the next piece to talk about is co-pack agreement. So most of the time, if you're doing an NA product, you're going to be co-packing versus doing it at your own facility. And there's a lot of issues regarding co-packers, especially if you're doing a can, which is one of the most popular categories. You can have issues of the can liner disintegrating. You could have issues of, especially if it's a CO2 product, the cans exploding when you stack them the wrong way or even the right way. And then one of the issues that keeps coming up over and over in my practice is, so I go to the co-packer and I want them to order, let's say, cans. I have the labels delivered, have everything delivered, and then the cans start exploding. And I haven't done anything because I wasn't even there. But the co-packer is going to say, well, your cans were faulty, or your labels were faulty. Whatever it is to get out of it is what they're going to say, because they don't want to be responsible for all of your damaged product. So it keeps coming up over and over and again, and you need to make sure that all of those things are outlined in the co-pack agreement. Otherwise, no one's going to know. Everybody's going to start pointing fingers at each other, and no one's going to know what to do, and you're going to be in litigation or not have product on the shelf regardless, and who knows, it's going to take years to figure out. And it's happened to several clients over and over again, unfortunately, and not ideal, which is why I always recommend a co-pack agreement instead of just taking it by chance. So you want to make sure, as I see, what exactly they're going to do and what it is that they have to order. So is it you or is it them that's responsible for the cans? If it's them, make sure that they are adequate for whatever the products are. Also, who's going to be putting the labels on, and is their seaming machine going to put tiny holes into the cans, which could potentially make them explode or not? So there's a lot of things that go into it, and you also want to make sure if you're using glass that when they receive all the materials, and especially the glass, that they check it and they clean it and all those different things to make sure bugs and other things don't get into it. And forecasting exactly. You also want to make sure that you have a sample and that they produce against that sample so that you can at least have some way to say, well, this doesn't match up and taste the same as the sample that we all agreed upon. Also, orders and timing of pickup. You want to make sure that you know how long it's going to take from the time that you order the product to the time that you can pick it up for, and how long you can have a warehouse there for free. Otherwise, you put in a PO and they don't make it in time for a big order. what's the recourse? And you need to be able to, say, hey, we're supposed to make it in this time. I need to get a discount or whatever it might be. And then again, claims. So those are some of the keys to remember in co-pack agreements. You also want to make sure that you own all of your IP. That's one of the more important parts. And that would include, of course, the recipe. So if they make the product for you and they develop the recipe, you also want to make sure that that was what they call a work made for hire, so that you own it, even though they made it for you. Otherwise, you can have them make the product, and then they can make it for somebody else, or you leave and they can start, replicating it. So you want to make sure that you own whatever it is that you're doing, and you're licensing your trademarks and intellectual property to them to make it for you. The other thing to remember is exclusivity. Do you want to be able to maybe have one in New York and one in California, or are they requiring you to only go through them? You also, again, want to make sure you know how to get out before you can get in. And then what happens after you terminate? Do you have to buy everything from them? What can you do if you have extra cans and all those other things? You want to make sure that they can't use them in the future and that you can take them back if you want them. You also want to make sure that you're indemnified. If they did something wrong and you get sued, you want to make sure that they're going to protect you.